All right, 268, who do we appreciate? Now, Minnesota Statute 268.095. What does that mean? Coming up next.
No information obtained from the following production is legal advice and does not create an attorney-client relationship with the law office IAJ, Law LLC, or any attorney or professional appearing on this program. You should consult an attorney for individualized advice regarding your own situation or specific legal concerns.
Broadcasting from Edina, Minnesota, your host, Attorney Jasper Berg. Hashtag Jasper.
Well, hello there. Thank you for joining me. Very likely you found this and you're searching on the internet of this number called 268.095. Really, there's a couple of situations when a person is searching for this term. In my experience, it's going to be the worker or a person who recently lost their job, and that worker received some sort of letter from the unemployment office, or they saw in their online unemployment account that the unemployment office believes this rule applies, and they will actually name that law in the letter that that person gets. So in my experience, why would anybody need to know this law? Really, it's going to be on a case-by-case basis based on a worker who is seeking unemployment benefits. Catering to workers who are seeking unemployment benefits, I'd like to break this rule down for you, and perhaps that this can be used to your advantage going forward. It's important to note that the best way to get a grasp of this law is going to be just to read it. And it does take some time to work through. And if there's a term or a phrase that looks kind of awkward, where it doesn't really make sense, for example, employment misconduct, an unusual term that most people wouldn't use in normal day life. It's important to acknowledge that terms in this law are defined by about 3,000 different cases in the history of Minnesota. What I mean by that is there are about 3,000 public cases that we can go to the library and read that help us define what the terms in this law mean a little more in depth. So obviously that's a daunting task for a short video like this, but I'd like to at least introduce this rule so that we can help ourselves organize it accordingly. So the very first thing you're going to notice is that it is a long rule. If you print it off, it's about 5 pages long. The rule is going to be divided into 2 categories. It won't tell you this, but it can be divided into 2 categories of workers who quit their job and workers who were discharged or fired from their job. Those 2 types of cases are not the same, and this rule divides those situations into a couple of parts. The worker who quit their job is probably going to want to understand and grasp Subdivision 1 and Subdivision 2. Those 2 elements tell us what it means to quit a job if a person doesn't understand or know what the definition of that process might be. And some workers are forced to quit their job. Some workers don't want to quit their job, and the employer is saying that they quit their job, in which case the other side of the coin is this thing called fired or employment misconduct. But when there is confusion, at a minimum, Subdivision 1 and Subdivision 2 are going to cater to the worker who quit their job. And when I mean cater, I mean they apply to that situation where it is clear that the worker quit their job. There are a lot of reasons why a worker does not want to argue that they quit their job. Likewise, there are a lot of reasons why a worker does not want to argue that they were fired. So this is a very fact-specific situation. Everybody has a different story because everybody has a different employer, different boss, different things were exchanged, different words were exchanged, different experiences brought to that career. So this is going to be almost a one-in-a-kind type situation. When a worker calls me and describes their situation, that situation is going to be unique to them and them only. These are only guidelines, so keep that in mind. So the point I'm trying to make is if a worker is clear on the side of I quit my job, the Subdivision 1, Subdivision 2 is where this rule is going to impact that case. Now, the worker who was fired or discharged from their job, they're going to lean on subdivision 6 and subdivision 6A. And in this section of the law, we're going to find this phrase called employment misconduct. And there are a bunch of reasons what is employment misconduct and a bunch of reasons what is not employment misconduct. Most workers who are fired from their job want to argue why the situation was not employment misconduct. So understanding what this term is, what the accusation is from the unemployment office, or the accusation of a past or current employer, is going to be significant on how this rule or law applies to that worker's situation. Now let me just go back for just 1 second. I blew right past subdivision 3. Subdivision 3 also applies to workers who quit their job. So subdivision 1, subdivision 2, subdivision 3, those are going to be elements of this rule that I believe apply to a worker who quit their job. And likewise, subdivision 4, subdivision 5, subdivision 6 are going to apply to the worker who is or was terminated without choice. Now, when there is a choice, things are pretty clear. When there isn't a choice and your employer is claiming something different than what you are claiming, that's where these middle parts of definition of quitting a job, definition of a discharge are going to come into play. That's why they are defined, because often workers sometimes disagree with their former employer, and that makes sense. I would disagree too. Other times, they are being labeled or painted a certain way just based on answers that they've given in an application for benefits, or when a person gets to the phone hearing piece of an unemployment appeal, they hear things from their employer that are very disagreeable. So knowing when these elements play into a case are going to be to that worker's advantage if they indeed are trying to acquire unemployment benefits in the state of Minnesota. There are other pieces, if you print off this law or this rule, there are other pieces that I'm not discussing. That doesn't mean that they don't apply. They just tend to not be the majority of folks when they are seeking some sort of appeal from the unemployment office. But absolutely, the remainder part of this law is a significant piece. So my goal here is to introduce workers who are seeking unemployment to this rule. It does come up more often than not. Knowing that it exists before it comes up, I think, is absolutely to a worker's advantage if they're trying to acquire this benefit. So take some time, look up Minnesota Statute 268.095, print it off, read it over and over and over and over again, and use it to your advantage. So with that, I wish you the best.
Jasper thanks you for listening. Please subscribe or share this production.